And here's our host, Tian Wei.
Hello and welcome to World Insight, coming to you from Beijing on CGTN. We begin today's program in Washington, where House lawmakers have asked over 80 companies for information on how their business may have been harmed by the tech giants. The House Judiciary Commission is investigating the influence of Amazon, Apple, Facebook, and Google. In response to these accusations, the tech firms insist their products benefit the consumer and face plenty of competition. Top executives from the four companies have until mid-October to supply documents and emails for the congressional investigation. Between Capitol Hill and Silicon Valley, though, there are also the consumers. So how will average internet users react to this antitrust battle? Let's find out.
Bad blood between Washington and the giants of the tech industry. Congress opened a new front in the government's antitrust probe of giant technology firms, Apple, Google, Facebook, and Amazon, with House lawmakers recently demanding documents and information on their business practices and company records by October 14th. The request comes at a time when all four companies face intense scrutiny. Google, in particular, has been hard hit. On September 9th, 50 state attorneys generals representing 48 states announced a new antitrust investigation into the search giant with a focus on the company's advertising business. 1 week prior, the Justice Department asked the company for information as part of its broad tech competition review. For the past 18 months, big tech companies have been under mounting pressure from regulators and lawmakers over their data privacy practices, culminating this summer with a massive $5 billion fine handed out by the Federal Trade Commission against Facebook. The probe marks the latest regulatory headache for big tech and the rest of Silicon Valley, which have faced growing criticism and widening scrutiny into whether they've grown too big and powerful, undermining rivals and burdening web users with even costlier and poor service.
For more on this, in New York, we have Harry First, a Charleston Dennison Professor of Law at the New York University School of Law and co-director of the law school's Competition, Innovation, and Information Law program. In Washington, D.C., we're joined by Ernest McDuffie, founder of the Global McDuffie Group. Last but not least, in Beijing studio, Andy Mock, Senior Research Fellow at the Center for China and Globalization. Want to welcome the three of you. Professor, go to you first. What's likely to be the legal implications for what you call the GAFA, or the four tech giants from the United States, with the latest investigation by the U.S. House?
Well, first of all, these four companies are being investigated by more than Congress. I think that the congressional investigation probably poses the least concern for them. It's possible there'd be some legislation, but what they should really be concerned about is potential litigation from antitrust enforcement authorities. And they certainly are under investigation by a lot of the U.S. antitrust enforcement authorities.
Mr. McDuffie, now, some of the insiders of these companies, certainly Mr. Bill Gates is one of those who've been a big name for decades. He's been asking whether it is going to benefit everyone to break part of the companies, or should I say break apart these companies, since we're seeing an antitrust investigation against these companies. What do you think?
Yeah, I don't see an immediate benefit to breaking up any of those companies, but it's not something that I've studied in any detail. The idea of any antitrust is to prevent prices from going up unnecessarily, and to prevent any stagnation in innovation or quality. And it seems to me that these companies are still competing against each other and others in innovation and pricing. In fact, most of the services are actually free. So I don't see that there's an issue there. The issues are more on the what's possible with the technology in terms of privacy rights and and those other kind of issues. And I think all that stuff is still being developed.
Well, you could argue that a lot of stuff are being developed, but it does not mean, or does it, Professor, that during the process of development and during the process of innovation, antitrust would not be exercised?
Yeah, so I would disagree a little bit with the earlier statement, and not quite sure what Bill Gates meant. It is possible that at the end of the day, antitrust authorities would try to break up some of these companies, and that has been suggested. But the more likely impact is that their business practices will be restricted. And for that to happen, you have to find that the business practices actually harmed consumers. It's not impossible that that's the case. There have been lots of concerns about what all of these companies have done. And although it is true that some of their products appear to be free to consumers, they are making a lot of money from various parties who have to deal with them. And consumers do give up a lot of data in return for what are apparently free products. So I think that the purpose of these investigations now is to actually uncover the kinds of business tactics in which these parties have been engaged. And I think we're going to find out a lot about the way that these four companies compete, including acquiring companies that threaten their dominance.
Very interesting. Mr. Mark, now, when you look at the antitrust today, it's going to be a very different lens compared to earlier times. It's very different how monopoly, quote unquote, is being done today, and the impact of monopoly, rather, is being done today. Mr. Mark, do you agree with that?
I absolutely agree with that, Tianwei. I mean, one of the challenges that the government, the legal enforcement apparatus is facing, whether we're talking about Congress, whether we're talking about the Department of Justice, whether we're talking about the FTC, whether we're talking about the attorneys general, is that law is always playing catch-up. And that's just the nature of the legal system, is that they're reactive. And what's going on here is the tech world has evolved so quickly. As Ernest was saying, it's quote-unquote free, but it's really not free, because consumers are not paying with their money. They're paying with their information, with their privacy, and it's actually a very costly deal for consumers. And I think the conceptual framework has not caught up with this yet. We have to have a new framework, and then the legal enforcement can happen.
Professor, first, you think that will be the way? How long it will take, both the investigation and also the, shall I say, the public sophisticated assessment of the services and their relations with these four companies?
Well, we do have a precedent in this. The federal government and the states did bring suit against Microsoft in 1998. That's more than 20 years ago. And in some ways, similar cases involving a product, internet browsers that were apparently given away for free. Now, that took quite some time, actually. The case took years to investigate and litigate, and eventually to settle. And I expect that these cases will take time as well. So if they're done right, we're looking at several years and, frankly, new political administrations, perhaps, in Washington.
Interesting. And you add a precondition.
So don't hold your breath.
But you're adding a precondition if it's done right. Mr. McDuffie, now, you're from the industry.
Yes.
So let me ask you, do you think the industry would trust Washington and believe it would do it right?
Well, and generally, no. I don't think the industry or anybody has a lot of faith in government these days to do things right. The kind of infighting between Justice and FTC and the Congress, kind of indicates that there's probably some dysfunctionality happening at the federal level for sure. But I think the other point that the other speakers just made is the key point. 20 years ago, when the government tried to break up Microsoft, Microsoft had about 90% of the market share, and today they have about 35% of the market share, but they're still a thriving company. And I don't think that change in market share was a result of any legislation or anything that the government did. It was a result of market forces and what happened in technology. Certainly it's going to take a lot of time for these investigations to wind through the courts. And during that time, technology is going to be changing and progressing even faster. So, you know, I see it more of a distraction. I think these companies are going to adapt and look at what Congress is saying and look at what the marketplace is saying in terms of privacy and data and protecting that and act accordingly. And it's also more, yeah. I think the European, yeah, go ahead.
It's an interesting point you're talking about the Europeans, but you know, one of the things, Mr. McDuffie, you've been arguing from the very beginning seemed to suggest, well, this is a natural process. You know, when there's competition, when there is marketplace, different players are going to eventually fall into their right places, and eventually it's going to be a perfect scene without the so-called intervention of the government or of the legal, shall I say, the legal branch. But to you, Mr. Mark, we do not want to forget that it was the government that broke up Microsoft, that eventually Microsoft, together with the other players now active on the international stage, become who they are. Now, it's hard to suggest that even there is an anti-monopoly action against the Microsoft. Microsoft is still one of the strongest companies in the world because it's already been done. So you cannot take back the spilled water, that's as they say. But the question is, what is likely to be the near future, Mr. Mark?
Well, I think this is really the battle of the titans. So on the one hand, we have these four enormous tech companies arrayed against the various institutions of the U.S. government. I think how this can play out, breaking them up is certainly one possibility. Another is look at what happened with the financial services industry with Glass-Steagall, where there's a separation, a kind of a breakup. Look at utilities, where they're regulated. So I think all of these are possible. It seems there's a universal view that this certainly is a problem, so something needs to be done. You know, this relationship between the tech companies and government is adversarial. So whatever the government does, the tech companies are going to be looking to mitigate it. But what government should do, what good government does, is it acts on behalf of consumers who individually do not have the power to fight back.
Right.
So I think something will be done. What exactly that will be remains to be seen.
With the lack of trust that the public have these days in governments, as Mr. McDuffie earlier clearly pointed it out, are governments really still representing the public? In your country's case, for example, this is where the antitrust investigation is going on. So are they still similar or with one another, or actually the government's only representing itself now?
Well, this is a perpetual question. And I agree that I think it's up to government enforcers here to prove themselves in these investigations, not to settle for something too easy. I think these companies, as the earlier speaker said, will try to make some adjustments to, in effect, maybe convince the government that they don't have to do too much. So I think we're in for a longer haul in the sense that we want to see whether the enforcement agencies are up to these tasks. Now, I will say I do have a little confidence, in part because, as also been said, there is a lot of concern about this, about the dominance of these four companies. And it's a concern that, at least at the moment, appears to be quite bipartisan. In fact, much more so than it was in the case against Microsoft. So I have a little optimism that that we might see a real effort. And, you know, we do like competition, and it's not bad to have a little competition among these enforcers so that, you know, if one of them chooses to take a relaxed attitude, the other might not.
Mr. McDuffie, I cut you short earlier about an important point you were making, which is about what the other countries are doing to deal with these 4 tech giants, and not to mention others from different parts of the world. You mentioned about the Europeans' role here. Now, would you like to illustrate more?
Yes, certainly the European Union is ahead of the United States in terms of defining privacy and actually fining the big 4 tech companies for what they perceive as violations of that. They've had multi-billion-dollar assessments go out already. And the other point is that the technology, I think, and the advances in technology, the benefits that they bring to the consumers through these advances that, frankly, are not even predictable at this point. I think 5 years from now, the landscape is going to be totally different from a technological standpoint than it is today. And the legal system and the political system will be even farther behind than it is today. So, you know, I agree that there's a problem and that there is bipartisan support to make sure that these companies don't take advantage of the customers, but ultimately it's not to their advantage to take advantage of the customers, you know, because the customers will realize eventually that they're being taken advantage of, and they'll respond in kind. So the whole geopolitical struggle to deal with all this, I think, is necessary and can have a positive benefit, but in a lot of respects is irrelevant because the technology is going to swamp whatever they do.
You seem to quote the name of a very famous film, Catch Me If You Can. That seems to be the logic you're trying to suggest over here. Professor First, you laughed also as hard as Mr. McDuffie himself. Go ahead and help us understand better about that.
Well, the Catch Me If You Can is not just the investigation and the time. And I agree the law often seems to be slower than technology. I would point out that the software that was at issue to a great extent in the Microsoft case 20 years ago was the Internet browser. Everyone uses an Internet browser today. So technology may move, but once these companies solidify, it might not move so quickly. So the real challenge, frankly, in the end, will be remedy. And this was a problem in the Microsoft case 20 years ago, and it is the problem today. What do we tell these companies to do so that they will stop engaging in behavior that is anti-competitive and harms consumers? And this is going to be a real challenge for the enforcers and eventually for courts to figure this out. And this is the point at which Congress might have something to say as well. So, you know, catch me if you can, but the movie ends at some point. So stay tuned.
All right. How much can we stay tuned for, Mr. Mark?
Well, I think, you know, of course, this is an important issue, and it's getting a lot of attention. One thing I do want to add, though, is that there is a political wrinkle to this. So look at the Trump administration. Some of its actions have been called into question. With regard to this, Jeff Bezos owns Amazon. He's also been called out, attacked by Trump for his ownership of Washington Post. Google, of course, has come under fire. So I think this has the potential to complicate these enforcement, these regulatory actions, and throws this into even greater uncertainty. So we don't know what will be done. We're pretty certain something will be done. But now this political wrinkle as well, I think, needs to be considered, and that will affect, of course, how things ultimately turn out.
So you're saying that maybe this is not the best time to do it. Is that what you're trying to indicate?
No, I think something needs to be done, but I think that it will hamper the ability of government to have the legitimacy to say, it gives ammunition to the tech companies. It also, I think, will raise some questions of the legitimacy amongst voters and consumers as well. So it's a complicating factor.
That is an issue, Mr. McDuffie. the fact about the capability and the fairness of the government various branches to be able to exercise their right on behalf of the public to do whether it's an antitrust law investigation or other issues. But the reality is the reality. That's what you have right now. The question is, what should be the next step if a real antitrust investigation is being done for the best interest of the consumers? From an industry's perspective, what would you suggest are some of the aspects that the public should check out to see whether the investigation is really on their behalf?
Yeah, sure. I think you need a combination of knowledgeable people from academia, industry, and government to actually do a real investigation that follows the facts and science to determine whether any harm is actually being done, to determine what, in fact, harm is. Is the fact that customers are giving up a certain amount of data actually harming them? Is their privacy actually being harmed? And how do you monetize that? And what's the trade-off between the benefits that the technology provides versus those perceived actual or real harms? If an actual impartial investigation that takes the politics of this current administration out of it, the fact that they still deny, climate change, and they still deny that, meddling happened in the 2016 election. If you can take that out of the equation and do an objective investigation, I believe that the tech companies would respond to that in a positive way. I think the politics of it is a complicating factor, as the other speakers have said, that hopefully won't be as complicating in a few years.
Mr. McDuffie is making lawyers' job ever more complicated. Professor First, I wonder whether you really defy that tendency from Mr. McDuffie.
So I want to agree with that. I think that the way this needs to be done is through legal process. I think that having cases actually litigated in court before judges, where the parties have to prove their claims on both sides, is subjecting these companies to the rule of law. And I think there's a lot of virtue there, because it's sort of neutral legal principles and the fairness of the legal system to which I think people look. One of the unfortunate parts in the current administration is casting some doubt over that effort. But in the end, antitrust authorities are going to have to go into court, make their case, and the expertise they have and can assemble and the facts they find, they're going to have to present to a judge. And all the nice defenses that these companies put up about how wonderful they are, they're going to have to present those to a judge too.
I see.
This really is a virtue of our system.
One of the things very interesting about that process to come, as illustrated by the other two guests, is it's going to be a beautiful education process for the public to hear arguments from both sides and try to understand what is the real essence of this whole debate, who's speaking for us and who is not, who is only using rhetorics and propaganda toward us, I mean the consumers, not just in the United States, but also all over the world, given the fact it is a global company, Mr. Mark, that we're talking about.
Absolutely. And while I agree the legal process is indispensable, but I think it's not sufficient, because we need to discover new principles, new policies. What does privacy mean? What does harm mean? And I think this is where think tanks, research organizations, universities have a role to play as well. And this is also critically important, to come up with these new ideas, these new policies on which the legal system can then act.
Well, we're running out of our time for now for this discussion, but I really hope we are going to continue this conversation for the near future. For now, I want to thank the three of you, gentlemen, for giving us your insights and also providing us with a sense of humor as well. Harry First, Ernest McDuffie, and Andy Mock. Really appreciate it, gentlemen. Thank you so much.